Hello, everyone. Happy New Year. It's our first podcast of 2025. Welcome to Some America, Some Assembly Required. Anna Maria Reitzinger and I will be talking about the how-tos of building and operating our American state assemblies and committees. We do have a schedule of topics that we're working through. Currently, we're in the Jural Assembly and in the Jural Assembly committees. So we're going to ask you to keep your questions to that topic for today, in the hopes that we can finish up our committees today and move into roles and then into the Jural process. So as we go along week after week, we hope to address and answer your questions on building your state assembly. So let's stick to the topic and let's assemble. So I have Anna coming onto the stage. Hey, Anna, how are you?
I'm doing okay.
Good. Good.
Things are rocking and rolling in the international jurisdiction.
Oh boy. You sound like me. I had whatever that crud is, started Christmas night after I got home from the Christmas celebration. And it has just dogged me ever since. So we'll both be here, unfortunately, coughing a little bit together. So
my voice may give out. I'm sounding like RFK. Been talking too much.
Absolutely. So it's getting dicey out there, isn't it?
Yes, it is. Very, very important news coming across the airwaves. It's a couple of days delayed, but people are getting the news now that the U.S. corporation is dissolved.
We've been preparing for that for a long time. And we were talking about that a little bit this morning about, how everybody, I want to say, I think the first time I heard it was about August or September, when they kept saying, well, Donald Trump will never be president. He's never going to be president. There's never going to be either an election or a certification. He's never going to assume office. We've been hearing these tidbits all along within social media. And I said, what if the media people were basically, they're completely aware. We know that they are. And this was their way of telling us that this was going to happen without actually coming out and telling us, right?
Well, yeah. If you know that the bankruptcy is going to settle on January 1st, 2025, then it's a no-brainer that there's no corporation for him to be president of on January 20th.
Right.
Right.
Exactly.
And so it's just revealing more layers of fraud, going all the way back to George Washington.
Yeah.
Because when you start digging into it, you see that every single president from George Washington to Lincoln was a British territorial officer in the military, or was a bar attorney. So they were all king's men. All the presidents from George Washington to Abraham Lincoln were all in the same position, and they were all king's men who were operating as presidents of a municipal business, or later business converted to a corporation. So this has all been just a gigantic con job, and the people have not understood the actual presidential office of their government, their American government. They've been distracted by all this U.S. foo-foo-rah, and have been deceived into thinking that these presidents, these foreign corporation presidents, were our presidents. But in fact, those are just foreign corporation offices, foreign presidents who work for us, or who are supposed to work for us.
Yes, some of them worked for us and many of them didn't, which is why we ended up where we ended up in the stretch of everything. I noticed that a while ago, that the presidents seem to be all ex-military or, I did an inquiry at one point about our American government presidents. And you can't find it. It is like almost non-existent. They've buried it so hard. And yet you do know that, we all know that the Continental Congress operated until this around the Civil War that we
Right.
had that we had a Continental Congress. But the history has been buried on that so severely that you can't find the names or the people who were actually the list of presidents along the way in the American Continental Congress. And they only want to talk about the U.S. presidents, starting with George Washington. So I did notice that doing some research this fall, that was really such the case. I found that very curious.
Well, our federation presidents are elected by the state assemblies, which only makes sense.
Right.
So, the candidates for the office would go around to the state assemblies and answer questions and dog and pony show, and everybody would decide whether they were going to vote for candidate A, B, C, or whatever. And then the one with the greatest number of votes would, it would carry that assembly's vote, right?
Yes, exactly.
And, up until the Civil War, there were something like 32 states. So there were only 32 state assemblies involved in the voting process. And they were public they were public elections in that the public assemblies are public institutions, right?
Mm-hmm.
So they were by definition public elections, and the people who were involved in the assembly electoral process got to vote within the assembly. See, so say that I was running for president of the Federation, which is the president of the United States of America, right? I would go to each one of the assemblies, and we'd have debates, and we'd have different things going on. And the assemblies would get a chance to look at all the candidates, and then each assembly would take a vote on the candidate that they wanted, right?
Right.
And so that vote is from the assembly membership, and then the vote that actually elects the president is the entire assembly casting its vote according to how their members voted, if that makes sense.
Right. Well, the way I always try to explain that is, yes, we have assemblies who eventually will be comprised of our electors from our counties.
Mm-hmm.
And the counties will vote. The electors will they have a duty to carry that vote to the assembly and cast that vote on behalf of their county.
Right.
And then the assemblies, yes, exactly. Then the assemblies take that vote, whatever the result of that is, of the counties and in the electors from that, and then they carry that up the chain. The difference in our jurisdiction, everybody goes, well, how's that different? Right? The difference in our jurisdiction is our electors have a duty to carry our vote. They have no discretion to vote in the way they think, which is what happens right now in the other jurisdiction. They can vote however they think or however they're told to vote, right?
Right.
And so that makes a huge difference. Even though we're not directly voicing our vote in that jurisdiction, we are indirectly having our individual votes presented through our electors. and they have that duty.
Right. And it's the same thing with members of Congress. Their members of Congress are representatives who are basically proxies that have been handed authority by shareholders in a corporation, right?
Right.
But in the actual American government, the delegates to the Congress are fiduciary deputies, which is an entirely different office.
Completely.
So, right now you've got one fiduciary.
Right.
When this whole thing gets booted up, you'll have hundreds, and they'll all be just as obligated to function in a fiduciary capacity and according to the prudent man standard as I am.
Right.
So, they have a different responsibility toward the people than mere representatives who are casting votes as proxies, carrying proxy votes in a shareholder election.
Correct. So it's the same concept as we're going forward as a chairman on, say, a committee, right? They can't change what the committee decides just because they think that it should be something different. They have a duty and a fiduciary duty to carry forward whatever the will of the committee was and the vote of the committee.
Right. And, when they present the results to the General Assembly, they're free to speak their mind and say, I'm the chairman of such and such committee, and we did this project and this research, and here was the findings of the committee. I happen to disagree with the findings of the committee because I think this is blah, 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 blah. You can have dissent, okay?
Sure.
You can have dissent, but at the end of the day,
you can't change. Right.
Yeah.
Right.
Yeah.
Exactly.
At the end of the day, you do your duty.
That's right. That's right. That's exactly right. So today we're gonna. I know it's been a while since we visited this. It's almost a month, right? So since the last time. So we're going to continue to talk, and we only had the last two, the litigation committee and the land patent committee. And so I'd really like to get into talking about what our litigation committees look like now, what they're going to look like in the future, as our Jural Assemblies actually stand up and act and begin complete operations. So let's talk about what do our litigation committees look like right now. So on the Ohio Assembly, our litigation committee for the last few years, since 2021, they've really worked with people who were having issues with the de facto, trying to help them, either write notices or respond to court documents, or help them organize if they had to go into court, help them organize their issues going in there, and how to use the right language basically within their documents. And so we, just like last night on Ohio, we had a little litigation meeting over the whole tax, payroll tax issues. Because all of a sudden there are a lot of people who are starting to get notices from the IRS. Either, our letters were taken as frivolous communications, or some people have had their W-8 BENs or their W-4s marked exempt, refuted by either their companies or the IRS. And they're getting letters to that effect. So we had a litigation meeting last night to review what the Supreme Court has said, what our laws are, what our affirmation on that we put together when you submit a W-8 BEN and 8233, and how that all works together. Try to educate, knowledge, and then move them forward in their issue so that they have the ability to respond appropriately. And so that's kind of what Ohio is doing with their litigation committee right now, is assisting.
Well, you know, the IRS was a fraud. It was basically a kickback tax on a payroll, on the federal corporation payroll that got extended by more constructive fraud to the entire population. And now it's going away. You know, Joe Biden hired 87,000 new IRS workers, and now they're out of a job. They may not have been told that yet, but the corporation that they work for is defunct.
Right.
And, you know, the rest of us who are aware of the fraud aren't putting up with it. So we own the interest in the municipal corporations now, and we will shortly own the interest in all of the British Seamen's estates that were created under very dodgy circumstances. So as this is rolling backward, you have to think about this as sort of a stair step or domino fall process where, okay, the municipal corporation franchises are collapsed. Okay. And now we've gained the beneficial ownership interest in those corporations. Now the next layer is the British Seamen's estate, because remember they created this theoretical person, this British territorial person in your name, and conveniently they went missing and died. They were declared legally dead and intestate, so that it formed a public trust under Admiralty law. So now we've come back and we've claimed all of it all the way back to the original American estate. And we've just begun the process of transitioning all those municipal assets. And we will also then have to transition all of those British territorial assets. And the whole thing is it's time consuming, it's difficult, it's confusing. The records are not what they should be because, of course, this was a fraud scheme from day one. And criminals don't tend to keep real good records. And they also tend to destroy records. So it's a difficult situation, but just don't worry about it. As far as the
All right. So what we did is we just kind of armed our people who receive such letters in the way that they can communicate with their employer to calm them down, because they don't know. They're oblivious to this. And some of the payroll companies like ADP and Paycor and those people are pretty much the ones that are pushing, and their lawyers to pushing into these issues. So, we armed them. That's what our litigation committee does, is helps you understand what the law really is, where you stand in it, and then how to respond to, whatever issue it is that you're responding to. Right.
Right. And really, you don't need to make it any big deal. You just, need to observe the facts. I was never a U.S. citizen.
Right.
Right.
Knowing that Bevins versus the U.S. in 1818 says there's two separate jurisdictions, and they name those out, and to go and stand on your jurisdiction, right? And that's what we kind of help teach in litigation and arm people with is to know where you stand, how you stand, and what you need to do to respond. Okay. So let's pull out our crystal ball, right? And let's look into this future with our litigation committee when we don't have a de facto court that we have to worry about. What does that litigation committee look like in the future, Anna?
Well, it's not really going to have a whole lot of work to do anymore, because you won't have things like child protective services coming in and, raiding your home and stealing your kids.
Right.
You won't have driver licenses and all that sort of thing being misapplied to everybody. There'll be drivers and that will be licensed who will be commercial truck drivers, right? But they will have their own professional standard that they live by, and it won't affect the rest of us.
Right.
You won't have all these petty litigations and infractions and statutory requirements and all this 80 million little ordinances and codes and statutes that people are being bothered by will be gone.
Right.
You won't be dealing with that. And the only time that you'll ever wind up in court is if you actually injure someone or injure their property. So,
And I would see the litigation committee and the way I kind of see that in the future and have described it is it would be a great place for our common law counselors to assist someone in the preparation of a case on harm. So if they're a claimant, or if they're defending on a case where they may need assistance to pull their information together, they can get a hold of a common law counselor through the litigation committee to help prepare their defense as well. So it's gonna function. That's kind of the way I envisioned that it would function in those two directions, but not necessarily have to be, defending ourselves against de facto court, maritime, administrative.
But actually, the litigation committee in the future should be working with the law education committee, because what you're looking at, law is a big, big subject area,
It is.
And we need to have a bare bones understanding of how it all fits together and how it's set up, okay? But the litigation committee, for example, can keep rosters of common law cases that have been decided about different topics and can engage in discussions and evaluations of what those decisions really said and meant. And you've got this very useful sounding board provided by the litigation committee to evaluate the merits of a case one way or another, with the light shone on them in the present day from past similar circumstances. So I think a litigation committee is a very valuable part of that education function and can get down into more nitty-gritty than just education about the law in general. I think the litigation committee is where you can get down and look at individual cases. We were just discussing Murdoch versus Pennsylvania, which is a famous case in which the ability of a state to unlawfully convert a basic right into a privilege and license it and charge a fee for it was permanently curtailed by this case. And there are other sporting cases too that speak to the issue of licensing and where licensing is not appropriate. So, the litigation committee can get down into that case, look at it, and say, oh, here's what the real issues are. And here's the kind of state that was being referenced. And, if it applied to a state, does it also apply to a state of state? And you can get into these very useful conversations to determine the jurisdiction and to determine the history of the common law concerning the issue. And you're going to find that in our law, under our law, licensing doesn't exist for, things like driving, practicing in court, providing physicians assistance. None of that stuff is licensed.
Right. And, that's where, as we move through, and I encourage, as we go through, really look at that body of law, and everybody goes, oh, well, that's from, 1818, or that's from 1843. Oh, it's still standing. Unless it gets repealed or, what do they call that? Overturned. By a latter court decision, it still stands as law. And so, we have to really go back and kind of look at these things when we're looking at the issues. I love perusing. I know I'm weird. I love perusing Cornell Law, their website, because you can pick a topic and you can get all of the Supreme Court decisions on that topic on that website. And it really helps you if you watch how it forms from the early history in law on our country all the way up through. You can see how they build upon the cases, and you can see the antecedent cases happening as they go along and the reaffirmation of those decisions. Our right to travel has been affirmed, I don't know, 100 times by the Supreme Court. Yet the administrative courts want to ignore it. And when you start bringing it out, they start to squirm. So, you really have to look at it and build on it like a history, like a provenance, and show in the law how it's been built all the way up to where it needs to go. And that's what our litigation committees should be doing, is taking those topics and really drilling down on them and showing the history of our rights, essentially our unalienable rights. So great. So we're on track with litigation committee, and as we move forward, and again, where we have the most effect is getting our assemblies standing and our Jural Assemblies standing, and being able to put all of this into place. Okay. All of it.
Yes. I just wanted to quickly read this for people, because this came out over the weekend, and there's a press conference going on right now. And this is, it's really
breaking news.
Yeah, we are entering a new period in our organization of our government. Okay. This was issued on January 4th from Donald Trump, President-elect. This was to inform all patriots that effective immediately, all governments and government corporations are hereby dissolved due to breach of oath. Additionally, all statutory and foreign laws are also dissolved. The only legal frameworks that remain in effect are constitutional law, as outlined in Article 61 of the Magna Carta, and established common law. This directive is specifically for corporate bodies and government workers.
Wow, that's awesome.
Any government corporate body, including police, judges, lawyers, and any individuals operating in these capacities, must cease operations immediately. Those who continue to operate after this notice will be liable for prosecution for fraud and breach of oath. It is imperative that all government workers comply with the directive. Failure to adhere may result in serious consequences, including potential military action. Let us unite in upholding our constitutional rights and ensuring the stability of our freedoms. Now, from my standpoint, this is very curious. And this goes along with what a litigation committee, for example, could be tearing apart right now, as a current topic. Because, okay, isn't it interesting that the reason being given for this shutdown is that there's a breach of oath? Well, we haven't had public oaths in this country for 16 generations because all of our public offices were vacated.
Mm-hmm.
Okay, so we haven't had a proper oath in 16 generations. And then in 1991, the Territorial Congress fiddled around some more and rendered the judiciary oath useless. Okay,
Right.
So they basically made the judiciary a lapdog of the Congress in 1991 because the judicial oath no longer requires the judges to render decisions that are agreeable with the constitutions. They took that one little section out about the duty of the judicial officers to render decisions agreeable to the Constitution.
Yet Marbury versus Madison stands as stare decisis in terms of anything that's repugnant to the Constitution is not permitted, right?
Yeah, well, in our courts, that's certainly true. But when you get down to the level of corporate tribunals that are concerned with their own internal laws,
right,
then it has no standing, it has no basis for consideration. And that's why when you would go into these courts, they would look you right in the eye and say, if you bring up the Constitution one more time, you're going to be in contempt of court. That does not apply here.
Right. That's right. That's exactly right. Because I always equate their statutes, regulations, and codes to the employee handbook.
Mm-hmm.
And my statement would probably be, I'm not your employee. I'm not a U.S. citizen. And therefore, your statutes, codes, and regulations do not apply.
Right. Well, now, and in this notice, isn't it interesting? This directive is specifically for corporate bodies and government workers. It's not for the general public.
Correct.
Okay. So
That's awesome.
my position has always been that all this stuff doesn't apply to us. We're not government dependents. We're not government workers. And we're not corporations. So, all this stuff over here doesn't apply to us.
That's right.
And here it's being admitted.
Jurisdiction. Okay. Yes, exactly. Exactly. So yeah, that's awesome. And yes, it does go hand in hand with what we're talking about in terms of the litigation committee, being able to tear that apart and make that, again, knowing what your jurisdiction is and standing on it and standing on the body of the history of our law is really important. That's what our litigation committees help us do.
Right.
In there.
I think it's very interesting that apparently Donald Trump doesn't realize that British territorial and municipal citizens have never had any rights under the Constitution. They live under the Constitution. They're obligated to uphold the Constitution, but they don't derive any rights from the Constitution. They don't derive any guarantees because they're not members, they're not parties to the Constitution.
Right. Right.
So, there's so much that people need to know. I mean, even taking a job for the federal government should require that people know that they're suspending their constitutional rights for a period of time.
Right.
Like when our guys sign up and go into the military, they're signing away their constitutional rights for the time that they're engaged on a tour of duty until they're discharged.
Right.
But they're never told that. And that's one of the things that they should be told. They should have also been told that they were engaging to serve as mercenaries. They were never told that from the time of Lincoln until today. They were never told that.
Right. Right. Okay. Well, as we move on, I think the land patent issue is going to heat up here this year too.
Yes.
And especially as the state assemblies stand and they can prove their competency as a standing government and able to take over or direct the state trusts involved, because all of our land was put into state trust.
Right.
And so those trustees hold that. And today I got asked the question from someone. They said, do they make money off of that? And I said, oh, you bet they do, because you were given a title, but they kept the deed. And that deed is printed on what? Bond paper. And they take it out onto the bond market and they trade it for basically additional funds. They're making zillions.
Can you imagine the upset that the dissolution of the United States Incorporated will have, and what the subsequent dissolution of the British Crown corporations involved in this will have?
Oh, yeah. We talked about that a little bit this morning. Is, we have to be prepared on our assemblies, which is why our standing is so vitally important, that if we have to assume a failed business, right, that we can walk in and begin to make those assessments and essentially take over those businesses. Now, it is an amazing task if you've never had to walk into a business or a failing business and take over and redirect that, look at what's right, what's wrong, what's failed, who works, who doesn't, all of those things. I've done it twice. and it is a daunting task to go into that and sort it all out and figure out, how do you go forward and make it successful, right? And that's what we're going to be faced with doing on our assemblies. That's why it's all people engaging in our assemblies, right? We're going to need everybody we can get.
Right. And we're going to have to understand the economics of the situation.
Mm-hmm.
Because when we claimed all those, long ago we claimed the beneficial interest in all those U.S. corporations and estate trusts and et cetera, et cetera. We also claimed their debt.
Mm-hmm.
Because their debt is our credit.
Correct.
Okay, so now they're bankrupt. And they say, oh, well, we can't pay any of this, right? But what's happened is that the territorial government has swooped in and secured our assets for us. So it becomes the responsibility of the territorial government to return our credit to us. See, all these games that they play to try to avoid accountability for what they've done.
Sure.
At the end of the day, it all comes back to them. We're just in the first round of the entire process that will hopefully render some justice here for the living people.
Well, then you add to that, here all over the country, and I know Texas and I think Florida, there's a beginning to be a growing body of states who have basically filed almost a RICO action, or have filed a RICO action against the state over land taxes. Because what the state did was they went in and a lot of people received a tax increase this year on their land taxes. And what the states did is they put this scheme together, and it's been proven, where they put a budget together and then told their auditors, we need X amount of dollars from the land taxes to be able to meet our budget process and what we need to plan for this year. So you figure out how to revalue the property to collect taxes, and you get your property value auditors out there, and you take and revalue that property so we come up to our income goals for our state.
Yeah, and actual fact, housing and other parameters are falling.
Mm-hmm.
Houses in many different states are now at 50% market value of what their book value is. So you may be stuck paying for a house that was assessed at $450,000 that's now only worth $150,000 on the market.
Right.
And this is all bogus. This is all just fraud, self-interested fraud on the part of the corporations, because they should have to adjust their assessments according to the market value, the actual market value. And, if that means less money for them, too bad. But actually, in terms of us, we're not even property owners in that sense. We are beneficiaries of a state land trust. And when we show up, that land trust needs to dissolve. And our individual private property ownership right needs to come forward and be paramount with respect to the state trust, such that the landowner is not being charged property taxes on his own land. It's one thing to be charged a tax on some sort of service area. Okay, that's a different kind of tax. But to be charged property tax on your own land is outrageous.
Right.
So that's a British thing. That was a British institution that was brought over here along with the British National Trust concept, along with the British land title system. All that stuff is foreign. All that stuff is British. None of it has anything to do with any American. And it should never have been imposed here or upon us. And it was, but, it just means that their debt to us is that much greater. And really, they've tried everything they can to avoid accountability for what they've done here. They have taken large sums of public assets and tried to convert them into personal assets of the British royal family, for example. But it's not working. They are being caught. Their assets are being seized upon, and this whole big con game is being deconstructed. And so, anyway, I want everybody to know that when a land patent or a land grant is made, it's permanent.
Mhm.
It's not something that can be jerked away from you on the whim of a county government or a state government. It's a permanent thing. It's yours. And they have been using these land titles, which are foreign and which are supposed to apply only to British territorial citizens' um, uh, holdings in this country. They have applied this foreign system to everybody and everything uh, without any basis for this. I mean, it does not change the ownership of the land patent or grant.
Correct. Correct. So just so everybody understands the basis of land patent or land grant, in the early formation of our country, we had no money. Gosh, we're right back there again. And so during in the Revolutionary War, the Continental Congress decided that those who provided faithful service on behalf of the Americans, they were going to grant them or patent to them land instead of money. And generally that was done in 80 or 86 or 160 acre tracts, where they basically gridded out. And if you go back and you look at some of the original land patents, that's the way they did it. And that was their payment for their service in the Revolutionary War and in the Continental Congress. Usually Continental Congressmen received grants, so they received land at a discount. They had to pay something for it, but then they received it at a discount from what it was. As I've told you, Anna, one of my ancestors here on Ohio, a great uncle, was John Cleve Sims of the Miami Purchase. And so he was granted basically that land purchase because, one, he was a general in the Revolutionary War. He served in the Continental Congress, and then he was also a Supreme Court justice, the first Supreme Court justice of New Jersey. So he was given this grant for this swath of land that they call between the Little Miami River and the Great Miami River. So it's this little triangle right in the center of Ohio that was originally Virginia territory. Okay. So he was given that grant, but all over Ohio and where I live, I don't live in that area, unfortunately. But where I live on the other side of the Great Miami River in southern Ohio, our lands over here were all land patented. So our original land here, I went back and traced, went to a man named James Dunn, who was I think he was a captain, and he was granted our land patent here for, it was like originally 160 acres. And then what they would do in order to create money is they were allowed to then sell off plots of land within that land patent and collect funds from that. They would collect money from anybody who could pay for their, plot of land. Sometimes it was 5 acres, sometimes it was 80 acres. It just depended on the time. But those plots of land then started to provide the monetary reimbursement to the soldiers. However, when they made those land patents, and our land patent was signed by James Madison in 1806, on that patent, it says that that patent belongs to this man and any of his heirs or assigns. And so what we need to do in our land patent is we need to think of ourselves, if we're not an heir to that land, if it's not been in our family all along, then we need to think of ourselves as assigns, because assigns means that you were assigned to that property for an exchange of value, right?
Right.
So when there are no new land patents, right? We're not applying for new land patents.
We're claiming them.
We're claiming them and coming back and basically certifying ourselves, or whatever, however you want to term it, affirming ourselves as the assign of that land patent.
Right. And our government is similarly has claimed that we are I guess you would say, the responsible parties that are claiming all of these land patents for all Americans who have land patent interests, so that they can come forward and declare their interest in their land patent.
Oh, let me hold your hamburger you just paid for until it's good and cold, right?
Well, folks, it's like my little story about my codicil of the Blueberry Hills. I can walk up there and I can pick those blueberries and bring them home and eat them, and that's all just fine. But if I don't exercise my right to go pick those blueberries, well, then any bear that happens to stumble along is welcome to them. You see?
That's right.
And it's the same thing with land patents. You have the right to claim your land patent and to verify through a chain of title that you are the proper assign of that land title, but you have to do the work and claim that land title. Otherwise, that land patent. Otherwise, all you've got is a land title. And you can choose, you can figure out for yourself just how much value those land titles have, since they're foreign and fraudulent.
Right. So when you talk about a chain of title, I always compare that to sort of like a chain of evidence. You have to prove that there's not a broken part of it within. So what you have to do is you go back to your county recorder office, generally, where the titles are all recorded in the deeds and titles. And it was really interesting. We've done this. And our county office, when we bought our property, where we built our house, we bought it off a corner of an 80-acre farm. Okay. And as we went in and we asked the recorder, we went to the book of conveyances. That's what they call it, the book of conveyances. Or you have to, a lot of counties have it on digital. So you have to go to the digital registry of conveyances. Okay. And when you look it up, it's basically 2 columns for the most part. And it's who sold it and who bought it. And you have to go back through this book of conveyance. And our patent, our title was the last one handwritten in our county for our property. Okay. There is no digital on our property whatsoever. So it makes it a little harder, because you have to go to the book of conveyances. You have to find your purchase, who you bought it from, and then you have to take that name and you have to go back and you have to find out where they bought it and who they bought it from, and then you go back and you find out where they bought it and they bought it from. And when you're doing that, you get this list of, it's in book number 1000, on page such and such, so and so. You have to go back to that book And then you have to find a copy of the title in there, and you have to write all the information down, what page it's on, what its number was, what, blah, 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 the whole thing. And once you do that and you get all the way back, you'll finally get back to where you find the land patent or land grant. Now, it takes hours. Digitally, some counties are fortunate. They have put those on digital after a certain date. But sometimes when you get to, say, 1986 or 87, it's all handwork at that point because it was all on physical books. And none of that was digitized. They just had a cutoff point and moved forward. Okay.
Yeah.
So that's kind of, so everybody knows what that process looks like and what you have to do. And the goal is to find and get back to that original land patent. Once you have all that information, you can go and put in an order and get a certified copy of each of those conveyances. So the titles all the way back for each of those conveyances. And that's part of the research that right now, even though we may not be able to successfully apply for our land, are assigned to the land patent, some states are just, Ohio is horrible about it, okay? Draconian. And right now, they won't be soon. But once you have all of you can do all of that research, then turn around and get that ready so that when it comes time to apply, you got to get your original land patent from the Bureau of Land Management, many of us, especially east of the Mississippi. And you get that certified copy as well. Then once it's time for you to go ahead and approach the state trust to get your property out and your county records to have you as an assign, then you've got that body of work done, correct?
Right. You can show all the way back through all these different conveyances that you're now holding the torch here that's been passed along through all these different transactions, together with all the changes that have happened, the easements, the driveway entrances, all these things that have been entered upon the land over time have now come back to you. So you're the guy at the end of the line that's holding the torch, right? You're the one that has the current interest in that land. Now, when you pass it on to your son or daughter, or you decide to sell out and sell it to your neighbor or whatever you're going to do with it, then they become the present owner, right? And that's that wonderful word, present. We are here in the present. We don't have the capability, because we're not immortal, of having an eternal title to anything. We're all just passing through. But at the present moment, we are the present owner, you see. And that has a meaning, a temporal meaning, that a lot of people kind of gloss over and don't think about. But when you're the present owner, nobody else can claim to be the present owner. If there's a present owner, that's the end of the entitlement system right there.
Right.
Okay. So we're hoping to get more people trained up to act as land patent clerks that can help with these chain of title investigations. They get kind of complex, especially in the Eastern Seaboard, where they've had so many more generations of land transactions than, say, in Alaska. Now, even in Wisconsin, and mine was a very simple case, is my great-grandfather bought the land from the original homesteader, and so he acquired land that had been Homestead Act land in Wisconsin just shortly after statehood in 1848. And so the land had only actually been held by like 3 members of our family. So it was very easy for us to go back and go boom, 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 and here we are. But that's the exception. Most parcels were not maintained in the same family for generations. Most land parcels are bought and sold and are changing hands and changing familial relationships over time. And so it can be very complex to do a chain of title search, even in the Midwest, to get back to your patent and claim your patent. Now, hopefully, people are not going to have to claim their patent anymore. Hopefully, most people who are not British territorial citizens will simply own their land free and clear, and property taxes will not be applied to them. And, this whole idea that the British trust was responsible for us and for our property is ridiculous. They were here as chiseling bastards, to put it mildly. And so in resolving this in our favor, we are simply taking back what was ours always, and what we should never have been charged any property tax on, and should never have been subject to the kinds of claims and losses that so many people have suffered over the years, because we were never British territorial citizens, and we were never citizens of the United States municipal government either.
Right.
These were just gross presumptions that were undertaken in breach of trust and in self-interest. So hopefully, in days to come, you will simply inherit your land patent as you buy property, and all these titles, these different descriptors that have been applied to your land will also vanish, because as I pointed out, these are just descriptions that some little girl carrying a clipboard went around and looked over the fence and said, "Oh, I think I'm going to call that 4232 Mockingbird Lane."
Yeah. We had 17 conveyances of our property of where we are between that and the land patent. So there were 18 conveyances. And one of them I'm still have to find, and I may need to get the recorder's office, because it was conveyed to a daughter from a father during the Civil War. And that back then, it was unusual for a woman to be able to inherit property, but she was a single woman. And it may be also something that they turned around and put into a brother's name in order to convey the property, and we just haven't found that particular conveyance. And then again, that was right about the time, amazingly, our courthouse burnt down.
You've heard this before. This is a common story.
And so it may have been lost somewhere in the fire, So they may have to recreate something in order to get our full chain of title all the way back through. But we can show where it is in the conveyance book. It's the title that doesn't exist. So.
Well, they had problems being able to pull this off when they first started it, because there was no system in place for them to do this. Mm-hmm. They had to create it as they went. And oftentimes what you find around that circa World Civil War era is that they just started calling it something else. And there's not really a break in the chain of title. It's a change in the scheme of describing the land.
It's moving the cheese.
Yeah, they've moved the cheese. They went from Plat Book 71-10323 to Plat Book 103-5242.
Right.
And it's not really lost, it's been converted. The legal term, it's been unlawfully converted. And they tried to cover that up. They tried to kind of gloss over the conversion. But there's always a conversion involved with any property that was established prior to the Civil War.
Mhm.
If it was after the Civil War, then the entire cadastral survey and everything was under the title system. And you have a patent underlying it, but everything was in the same title system, so that whatever changes the title system undergoes, it's all connected.
Right.
Now, the Queen of England had nothing to do with any of this, and neither did her father, and as it turns out, they weren't even kings or queens. So this has all just been done in fraud by a bunch of bounders who never got caught. And now that they've been caught out, it pretty much erases British history back 300 years, and also erases a lot of what went on in this country. It turns out that, for example, King George the Second wasn't King George the Second. So, it throws everything up for grabs. And we're just we happen to be standing here with realizing all of this with our arms wide open, going, "This is our stuff. You guys keep your stuff. This is our stuff."
There you go.
So we are all in a situation where we need to be aware. We need to be thinking. We need to be
Preparing.
drawing together. We need to be helping each other. We need to be developing the services that people will need to face this, which means more people becoming educated as land clerks. We do have a new land recording service, which is specifically to list your patents. Okay, and over time this will expand so that the BLM database of land patents that were under the U.S. system of land patents will be correlated to your range and township descriptions, and you'll be able to go down there and go, oh, well, my parcel is the southwest 1/4 of the northeast 1/4 of the, of township range 22 north, 14 west, okay? And you'll be able to go, oh, well, then that's my land patent too.
Right.
And we hope to get this all organized and computerized so that it's a fairly simple process, that when you go on this new land patent registry, or as we call it, land patent record, it's an LRO, it's not an RS, for us, for Americans, you'll be able to go right down the line and go, boom, okay, there's my land patent number. Oh, and I claim that. And you publish it on this new system, and it becomes public record.
Yeah, there is so much to this, and it's going to be, I hear Florida is discovering some success and some process. I'm going to try to speak with them real soon about specifics of their process to see if that helps us a little bit. But, realize that that's coming. But it's an issue where we really need to work on getting our committees in place and our state assemblies standing so that we're ready to assume the responsibilities of these trusts and the assets of those and get them back in the hands of our people. And the biggest deal about our land patents is, one of the rights that we were given was a right to property when our country was founded, and to private property. And that's what has made us such a huge target in the world, among the British, among the Spanish, among the Italians, among the French, to try to conquer us and assume us, is because each one of us have that private right to property. And so that makes us very valuable targets, in terms of having our sovereign properties, right? And our sovereign states. So, it's really important that we understand, again, the history that goes into, why we're doing all of this, and why it's so important to be able to claim our chain of titles and get that all straightened around, so that when that day comes, we can raise our hand and say, I've got proof. I've got the proof. Here it is, right here. So, so I imagine as the land patent office develops a little bit more, Anna, you'll have more details for us then on that. And
Oh yeah, absolutely. But see, it was so hard for people to publish their interest claim because they had to keep it on a public bulletin board for 60 days.
Mhm.
So there you are, going down to the public bulletin board and taking a picture of your posting for 60 days. I mean, that's crazy. So this was an answer to that need that one of our farmers in the Midwest decided to answer. He had a background in computer science as well as his expertise as a farmer. And of course, land and land titles and land patenting is very important to farmers. And so he developed this system for us, where we can all go and we can publish our land patent interest, which it just greatly simplifies everything, because then it's on the record. You can tell right away that it's been there for more than 60 days. If anybody is trying to research a particular piece of property, they can go there and they can have a database, a searchable database. So it's a wonderful step forward. Right now they're just working out the last little tweaks and twerks and bugs in the system where, this button works, but it doesn't work quite as we want it to, that kind of thing.
Yeah.
I'm sure that they will be launching very soon. They'll have online forms. You'll be able to enter upload your documents, your chain of title documents, and make your patent claim. So
Right.
It's a wonderful new service, and I'm sure that they will extend it as they go. Hopefully they'll have land clerks available in the not too distant future, where you can locate someone in your state who's trained to do chain of title work, and you'll have some resources there to make the appropriate claims.
Right. So, if somebody's considering the purchase of property right now, you usually, when you buy a piece of property, you do a title search, right? You have a title company that does a title search.
Right.
And when you engage that title company in your contract, you should add that you want a chain of title back to the original land patent or land grant.
Right.
It's going to cost you slightly more, but you're already paying for the title service anyhow.
Right.
So add the little bit more that it costs you for your title company and have them do the research. Now, there are some I've heard there are some titles companies that will not. They refuse to go back to the land patent. Okay? Go find another title company is all I can tell you. Find one that will. Okay? But if they want your business, be firm about it and say, hey, if you want my business, then you're going to have to go back and you're going to have to provide all the way back. And oh, by the way, I'd like certified copies of all of those, right? Get it done right up on the front, and you'll save yourself a bunch of work and later on a bunch of money having somebody else do that research for you. So that would be, I guess, one of my pieces of advice if you're looking for property right now to go ahead and do. So let's take a few questions because we've got about 15 minutes. Let's see here. Start up here. Let's see. So, Jural Assembly Handbook says courts can hear mixed jurisdictions, page 3. Is this for civil and criminal cases? Number 2, claimant equals ASN or ASE. Would accused have to be a woman or man representing the accused corporation?
Well, they do, in fact, hear mixed jurisdictions at times. Yes, because you can have a civil case arising from a criminal case and vice versa.
Mm-hmm.
Claimant equals ASCN. Would accused have to be a woman?
Representing. So there's not an attorney in our court, I imagine.
Okay. Yeah, you're misunderstanding what I meant there by mixed jurisdictions. There are commonly 2 situations where you can have mixed jurisdiction. That is the traditional case where our courts are operating, and you have both a decision from a land jurisdiction court and a sea jurisdiction court on an issue that has subject matter subject to either court. Okay, that's a split jurisdiction issue where you have subject matter that is in both realms. Okay, so for example, Penhallow versus Dones is a very famous case where you have a land jurisdiction court coming to one conclusion and you have a sea jurisdiction court coming to a different conclusion, but they're not actually addressing the same subject matter. Okay, and you have to look up the right version. You have to look up the land jurisdiction court to get the correct citation from the land jurisdiction perspective versus the sea jurisdiction perspective of the same exact circumstance. Okay, so you can have split jurisdictions like that, and you can have mixed jurisdictions like this where you're not really, it's not a mixed jurisdiction as much as it is a mixed change of venue, going from a criminal court to a civil court, from a civil court to a criminal court. For example, you could have civil damages related to a criminal incident. That's the most common case. Someone commits a crime, and they, in the course of committing that crime, they damage your house. Okay, so you have both a criminal action that is their crime, right? And then you also have the civil case, which is associated with it, that results in damage to your house. And so you're suing them for the damage to your house in addition to the court going after them for their criminal activity. So in that case, it depends on where the crime was committed.
So can the criminal court then assign a remedy in that case, or does it have to go back through the civil court?
Well, you do see some examples of a criminal case where there is a damage, but it's usually, in all cases that I know of anyway, it's a damage which is assessed on behalf of the public interest, and it goes back to the state or the whatever public entity was involved. For example, vandalism in a state park. The judge may, as part of the criminal sentence, give the person 16 weeks of public service as a sentence on the criminal vandalism charge, right?
Mm-hmm.
And it may also then order them to pay $2,500 as a fine to the state, which was operating the park, to cover the cost of repainting a fence, for example.
Mm-hmm.
So you do see some activities of that sort. I've never seen it as a personal case where a judge has charged a fine that was levied in behalf of an individual person.
Okay. All right, great. Thank you. All right. So I'll show this one. We have a hearing scheduled. Can we use the public court building currently being used by the de facto courts / government? If not, where should we hold a hearing?
Any public place. We've held, I'm so sorry. We've held court in the lobbies of businesses. We've held court in public libraries.
You can hold it in a public park. You can hold it in a school building, in a classroom. Bless you. And so that's okay. Again, one of the suggestions was that you can also a lot of us have historic courthouses that are now used as meeting centers, and they're already set up for common law courts.
Right.
So you could also do that as well, but anywhere the public would have access.
These guys rent the space from us anyway.
That's right.
They rent the courthouse space that they use from the state trust, and we can do the same thing, except that it's inappropriate because we're the supposed donors of the state trust. We shouldn't have to pay anything.
Right. So here's another question. Leanne's got a lot of questions. What would the official name of a state's common law court, of a county common law court? Do we use the word superior or supreme or anything else? Minnesota Superior Common Law Court.
No. Okay, look. Like I say, the truth is always simple. It's the lies that are complex. Okay? You have a court. What is it? It's the Alaska court. You don't even have to say state, because that can be somewhat confusing. When you say the Alaska State Court, you are inferring in their system that it's the state trust court that you're bringing an action before or in behalf of or against the state trust that they created. So our court is just the Alaska court. And your county court would just be the Macon County Court.
Right. Great. Thank you. Okay. Yeah, and Leanne has another question. How much should the bond be for a court case? the bond that claimant gives to the bondsman before court. The bond is really there to secure their attendance, correct?
It depends.
Okay.
Bonds are also used to prevent frivolous prosecutions.
That's true.
So when you have a system like they have, where you have a prosecutor who's bringing the claims or the charges in each and individual case, the prosecutor has to place a bond, a bid bond. It's called a bid bond, with the bail bondsman. And if they don't, then there is no case. And oftentimes these prosecutors don't want to actually post the bid bond required, because it's a substantial amount of money that they have to cover if they lose. Okay, so what happens? You go into court, the prosecutor has brought these charges against your purported corporation, right? You ask to see his bid bond and he doesn't have one, at which point the judge has to go, dismissed. So that's one of the very first questions that you can ask that often just derails the whole process, because the prosecutor hasn't done his job and hasn't actually posted a bid bond on the case.
Right. That's in their court, but
That's
in
their
our
court.
But
in
in
our
our
court, look, in our court, there's either injury or there's not.
Mhm.
And prosecutors don't get involved until or unless the claimant is dead. Someone's murdered, they've been injured, obviously, but
Right.
they can't speak for their own self. They can't bring forward their injury to the court, so the prosecutor does it for them. Or same thing with people who have been rendered disabled. If they're totally disabled or rendered mentally incompetent as a result of trauma from a crime, then you have a prosecutor. Otherwise, in our courts, everybody stands for themselves and has to, look their abuser in the eye and say, "Look, this guy did this, and it harmed me in this way, and here's how it happened." Bump, 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 bump. And so we have a very simple court system because it's all based on injury. In order for there to be an issue, in order for there to be a controversy requiring action by a court to resolve, there has to be an injury. And if there's no injury, then there's no case.
So with the bond process in our court, though, that's why I said it's usually our bonds are, it could be to cover court costs.
Bonds.
It's a performance that you're going to
Yeah.
end up showing up to our court.
Right. It's a performance bond, not a bid bond.
Right. Okay. All right. So we did talk about this, Betty, one of our former counselors of law do not do cross-examination of our witnesses. Counselors of law are only there to help counsel our people or step in case there's somebody either dead or disabled to a point where they can't present themselves. We have the duty to present our own cases in our own court. We face our accusers and our accusers face us. There's no go-between.
Right. However, a counselor at law can be like the little, the proverbial 3-inch person sitting on your shoulder, and he can be saying, "Ask him this."
Right. Yeah, they can sit next to you and be advising to you in that situation. Just
Right.
go watch an old Perry Mason, they're whispering in the ear, of a client here or there. But they don't actually ask the questions. The jury is the one that asks the probing questions.
Is supposed to ask.
That's right. They're supposed to ask. So that's a real change, and part of the education of our jurors, because they're not used to asking the who, what, when, where, and how, and why of questions. And so they're used to sitting back and listening and letting the prosecutor do that. In our jurisdiction, the jurors actually ask those questions.
Right, because the jury is responsible for the outcome. It's on them. And they have to be satisfied that they know the answers to the questions that naturally arise in their minds about the circumstance. If they don't have the answers to things that they consider to be crucial, then they can't render a decision. And so it becomes very important for the jury members to participate and for the jurors to forward their questions through the foreman of the jury for consideration, and even a process of back and forth questioning of witnesses and of evidentiary matters that are then posted with the court, right? Impaneled juries have a tendency to have a constant flow of people and evidence and everything else going back and forth so that the individual members of the jury can examine. And
Right.
so, but once that, the nice thing about it is that once it's decided by a jury, it cannot be overturned by any other force on earth, except if new evidence arises. If new evidence arises, you can have a new trial by a different jury.
Right. But that's why it's important for our jurors to get used to asking probing questions. So that, and if need be, the jury can request investigation, further investigation. So, it's really important for us to wrap our heads around that and include that within our jury education process, and getting them ready for court. So,
well, yeah, we have a real stunning example of this where a jury was considering a case that had to do with a tax and a claim against an individual to pay a tax. And one of the jurors asked, well, was the law requiring the tax ever ratified?
There you go. It wasn't. There you go. Sometimes it's just that one question you ask, right? Okay. One more question and we're done. If you have a mortgage, can you still make the claim for a land patent?
Yeah, absolutely. You won't have true possession of the property until you pay off the mortgage. However, chances are you never actually owed a mortgage to begin with. Okay, so you want to go ahead and claim the land patent and contest the mortgage.
Oh, there you go. Yep. Claim the land patent, contest the mortgage. Claim the land grant, assign the land grant, contest the mortgage.
And contest the mortgage because you were never a British territorial U.S. citizen, nor were you a municipal citizen of the United States. Therefore, none of that stuff, you're not responsible for paying their mortgage.
All right, great. Well, Anna, that's the end of our questions today, and we finished the committees of the Jural Assembly. So next week, we're going to get into the roles of the Jural Assembly, and then we'll get into the process of it so that we can dig into that too. Okay?
Oh, so, I can hardly wait.
I bet. So thank you very much. And we'll see everybody next week, and we'll continue on.
Upward and onward.
Upward and onward. Bye, everybody. Happy New Year.
Yes. Happy New Year.